Daniel Penny, the young Marine who restrained a drugged, mentally deranged, and threatening Jordan Neely on a New York subway car, after which Neely expired. A confrontation captured on viral video, which I'll share with all of you today. Now, Daniel Penny is currently on trial for manslaughter and criminally negligent homicide in a New York courtroom. But what really happened on that subway car that led to Neely's death? That's what we'll be covering in today's Law of Self-Defense show. Welcome, everybody, to today's episode of the Law of Self-Defense show. I am attorney Andrew Branca for lawofselfdefense.com. And for those of you who stayed to the end, and I surely hope that's all of you, I'll share with you how you can join us for a 100% free Law of Self-Defense HARD to CONVICT webinar coming up in just a few weeks. So Daniel Penny, the young Marine, restrained a drugged, mentally deranged, threatening Jordan Neely on a New York subway car, and Neely passed away in the course of that event. Penny's currently on trial on charges of second-degree manslaughter and criminally negligent homicide, and is looking at possibly 15 years in prison if convicted. Ultimately, the jury will decide either that Penny acted lawfully in his use of force on Jordan Neely, in lawful self-defense of himself and other passengers on the subway, and committed no crime, whatever. That's the defense narrative of innocence that would lead to an acquittal. Or the jury will decide that Jordan Neely's death was the unjustified result of either Penny's recklessness or criminal negligence. That's the prosecution's narrative of guilt that would lead to a guilty verdict. Now, there does exist evidence to support each of those competing narratives of innocence and guilt, including the viral video of the confrontation, which I'll share with all of you in today's show. And I have some of my own thoughts on what I suspect really happened on that subway car that caused Neely's death. Before I jump in, I want to remind all of you that if you're watching this on YouTube, it would be great if you could hit that subscribe button, hit that like button. We really appreciate that. Now, the jury in the Penny trial will be asked to choose between two competing narratives, a narrative of guilt presented by the prosecution and a narrative of innocence presented by the defense. The prosecution, in theory, carries the heavy burden of having to prove their narrative of guilt beyond any reasonable doubt in order for the jury to return a guilty verdict, while the defense need, in theory, raise only a reasonable doubt of guilt to secure an acquittal. The largely uncontested facts of the case are that Daniel Penny wrapped an arm around the neck of the erratically acting and threatening Jordan Neely, took him to the floor of a New York City subway car, and restrained him there for approximately 15 minutes until police arrived. By that point, it appears that Jordan Neely had expired. The prosecution narrative of guilt is that Penny either knew he was actively choking Neely for a long enough period to kill him and disregarded that risk, causing Neely's death. That's the reckless manslaughter charge, a Class C felony, good for 15 years. Or alternatively, that Penny was unaware that he was choking Neely sufficiently to kill him, but that he should have been aware, and his failure to be aware constitutes a gross deviation from the standard of care that a reasonable person would have followed, and that's the basis for the criminally negligent homicide charge, a Class E felony, good for 4 years. The defense narrative of innocence is that Daniel Penny did not apply any force to Neely that a reasonable person should expect would cause his death, that he only applied as much force as was necessary to prevent Neely from carrying out his threats to harm other passengers on the subway car, and was therefore legally justified as defense of self and defense of others, and that, in effect, Neely's death was simply an unforeseeable accident. With that background in place, let's take a look at the viral video of Daniel Penny restraining and or, depending on who you believe, choking Jordan Neely. Now, I caution that the state would argue this video shows Penny choking Neely to death, although the defense would characterize Penny as merely restraining Neely. We shared this video solely for purposes of education and legal analysis. We've tried to blur it out appropriately. We don't want to glorify death or violence. If viewing this video would be disturbing to you, we recommend not watching this content further. With that caution and context, we'll play that viral video now, and I'll go on and simply describe what's happening as it plays. Now, I would point out that it's not really possible to tell from the video how much actual pressure, if any, that Penny is applying to Neely's neck at any point in time. The manner in which Penny has his arm around Neely's neck could be applying sufficient pressure to constrict the carotid arteries that supply blood to the brain. If so, unconsciousness would typically occur in 6 to 10 seconds and death in 3 minutes or so if the choke were sustained that long. On the other hand, the same arm around the neck might be applying negligible pressure to the carotid arteries and be largely in place merely to restrain Neely from sitting up and being combative. Much is the case with Derek Chauvin's knee in the George Floyd case. I guess that people will infer however much pressure they need to infer in order to arrive at whatever verdict they desire. Someone who wants to believe that Penny choked Neely to death will watch this video and see a man being choked to death. Someone who wants to believe that is not the case will see a mere restraint hold rather than a lethal choke. There appears to be other evidence supporting both the state's narrative of guilt as well as the defense narrative of innocence. In the context of the defense narrative, Daniel Penny denies that he choked Jordan Neely to any degree likely to cause Neely's death. Other passengers in the subway car have recounted Neely's death threats and described their genuine fear, terror, of harm at Neely's hands. In the context of the prosecution narrative, the medical examiner attributes Neely's death to neck compression caused by Penny's choking of Neely, and therefore characterized Neely's death as a homicide. The state is not arguing that Daniel Penny intended Neely's death. In that case, the proper charge would have been murder, but rather that Penny's choking of Neely causes death in a manner that was reckless, that's second-degree manslaughter, or criminally negligent. That's the criminally negligent homicide charge. It's important to keep in mind that nobody, not the police, not the prosecution, not the judge, not the jury, perhaps not even Daniel Penny, knows what happened here in any absolute sense. The jury in particular was not in that subway car. The jury did not feel themselves the pressure of Penny's arm. The jury must arrive at a verdict based solely on the evidence and legal arguments presented at trial in that courtroom, within the context of the state bearing the burden to prove their narrative of guilt beyond any reasonable doubt. Still, we have what is potentially a lethal choking of Neely by Penny, and then Neely does die. Isn't that dispositive proof that Penny's choke killed Neely? What would be the alternative explanation of what really happened here, of why Neely died? Well, I have some thoughts, really maybe one step above speculation, but it's speculation based on my personal experience in both a physical sense, as someone who has applied precisely this type of choke to others and has been choked in precisely this way by others, as well as in a legal sense, as a lawyer who has consulted on similar choking cases in the past. In the physical context, this type of carotid choke is common in the martial art of Brazilian Jiu-Jitsu, and as a student of Jiu-Jitsu, I've both applied this choke to others and had it applied to me by others. It takes relatively little pressure on the carotids on each side of the neck to constrain the flow of blood to the brain and quickly induce unconsciousness within 6 to 10 seconds. Of course, in training, we generally avoid actual unconsciousness by having the victim of the choke tap out, so that the choke is released before consciousness is lost. Even in a real street fight, however, there would be no need to maintain choking pressure after, say, 10 seconds because the victim of the choke is unconscious by then. Sometimes there'll still be some muscular tension or motion, even at that point, falsely suggesting that the victim is still conscious. So I can imagine a choke being held for maybe 15 or 20 seconds. The notion that the choke would achieve constriction of the carotid sufficient to induce unconsciousness and then be held for the additional maybe 3 minutes necessary to cause death simply strikes me as not credible here. In fact, if the choke were held for the 3 minutes necessary to cause death, that would look to me like nothing other than an intentional murder, not merely manslaughter or criminally negligent homicide, and nobody, not even the prosecution, appears to believe that this was intentional murder. The prosecution has argued that any degree of choke is potentially lethal, and further that Penny would have known this because his Marine Corps training included cautions that chokes could cause death or serious bodily injury. It's just not true, however, that a carotid choke is inherently lethal. Again, I've had carotid chokes applied to me, and I've applied them to other students many, many times. None of us have died, nor would we have expected to die. Carotid chokes are potentially lethal, but only if they're held for 3 minutes or longer. Now, there is an alternative form of choke that applies not to blood flow in the carotid arteries, but instead to respiration. A respiratory choke doesn't target the sides of the neck where the carotid arteries are located, but instead applies pressure to the front of the neck, across the larynx. A respiratory choke can cause lethal injury in even a mere instant if the larynx is crushed. But I've seen no evidence that there was any injury to Neely's larynx, and the video does not suggest that Penny was applying pressure to anything but the sides of Neely's neck. So if I believe Penny was at worst applying a carotid choke to Neely and that this choke was unlikely to have been held long enough to account for Neely's death, then why is Neely in fact dead? What actually happened in that subway car? Well, this brings us to my legal experience with choking cases. I've seen numerous cases in which a victim of a choke died under circumstances in which the death would have been entirely unexpected if the choke had been applied to a healthy person, such as myself and other students in a martial arts class. In many cases, however, the victims of chokes are not healthy people. Often they're homeless, or alcoholics, or drug addicts, or all of those, with severely compromised physiologies, existing heart disease, liver disease, metabolic disease. These are profoundly unhealthy, frail people. And they're also often actively intoxicated at the time. And as a result, they're unexpectedly vulnerable to bad outcomes that would not occur to a more healthy person who was not intoxicated when they're subject to a choke. When these people with severely compromised physiologies and on intoxicants are subjected to a choke that would be harmless to a healthy, non-intoxicated person, they sometimes just turn off and die. And nobody is more surprised than the person who applied the choke. And that's especially true if the person applying the choke has received training involving healthy people who suffered no harm whatever from precisely the same choke. To put it another way, while the prosecution is trying to use Penny's Marine Corps training against him in court by suggesting that Penny possessed the knowledge that would make his choking of Neely either reckless or criminally negligent, that is, that he knew or should have known that his choking of Neely caused a substantial and unjustified risk of Neely's death, I would make precisely the opposite conclusion, favorable to the defense. I would argue that, in fact, Penny's Marine Corps training in chokes, training involving only people in exceptional health and fitness, as one would expect to find among young Marines, taught him that this choke technique was exceptionally safe and unlikely to result in any meaningful risk of harm, much less death. This is also what I expect was the actual cause of death of George Floyd, that it was Floyd's physiology and drug toxicity that killed him, in combination with his imprudent decision to fight lawful arrest for 10 minutes. That's what caused his death, not anything to do with Derek Chauvin's knee. Similarly, I expect this was the actual cause of death of Eric Gardner some years ago in New York City. That it was Gardner's morbid obesity and cardiovascular disease, again, in combination with his imprudent decision to fight lawful arrest, that caused his death, not the seatbelt type of restraint hold placed on him by police. And I expect this was the actual cause of death of Jordan Neely, that it was his physiology compromised by long-time addiction, as well as his current intoxication, in combination with his decision to forcibly resist physical restraint by Penny, that caused his death, not any extended chokehold by Daniel Penny. This is a concern I've raised in the course of my own Brazilian Jiu-Jitsu training as well, cautioning that if my fellow students find they have to defend themselves against an attacker, and their attacker is physiologically compromised, the carotid choke we normally think of as perfectly safe may in fact turn that guy off, result in the bad outcome of his death, and raise questions about whether it was the defender's choke that unlawfully killed him. This risk suggests that other non-choking forms of control and submission, like joint locks, might be preferred to chokes in this context. A joint lock vigorously applied can certainly destroy an elbow or shoulder or knee or any other joint, but it is vanishingly unlikely to cause anyone's death. It's unfortunate that the Penny trial is not being televised, because I'd like to have seen to what extent his defense team incorporates these kinds of thoughts into their opening and closing statements to the jury. But unfortunately, New York State, where the trial is being held, generally does not televise trials and is not televising this one. In any case, I expect we'll have a verdict in this case within the next few days, unless we end up with a hung jury and a mistrial. Okay, folks, before I wrap up, I do want to share with you how you can join us for our 100% free Law of Self-Defense Hard to Convict webinar coming up in just a few weeks. As the title suggests, this free webinar teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. The webinar is live streamed by me, and there's plenty of opportunity for Q&A. Again, it's 100% free, but we do limit seats to allow for adequate Q&A with all of you attendees. So I urge you to grab your seat right now before they're all gone, and you can do that by signing up at lawofselfdefense.com/hard-to-convict. I'll close up by reminding you all again that if you carry a gun for self-defense so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for lawofselfdefense.com. Stay safe.